Elliott. I'm a partner in the litigation group here in the Ottawa office of the law firm of Dentons, and I'm very pleased this morning to be joined by a group of experts and some of our clients and friends to discuss environmental crises, the management of risks and liabilities. We have quite a bit of material to go through, and there's certainly strong interest in this subject area, particularly recently, I would say, very strong interest given very recent environmental situations that have occurred here in Ottawa. For example, just a couple of days ago, for those of you who are following the news or live in Ottawa, we've had some flooding that has occurred locally. We've had sinkholes appear, and once again, people are talking about the environmental consequences of global warming. So this is a topic that is certainly quite timely. Today you are going to hear from leading experts on what kind of environmental crises you can expect, what kind of crises have occurred, and most importantly, how to deal and manage with those crises. So without further ado, I would like to introduce our panel. We have with us today somebody from BlueMetric, Tim Beckenham. First of all, BlueMetric is a professional environmental services firm with offices across Ontario, as well as Quebec, Yellowknife, and also one in San Salvador. BlueMetric is a public company with approximately 170 staff, and they perform professional services in environmental geosciences and engineering, industrial hygiene, renewable energy, water, wastewater treatment, environmental permitting, environmental site assessments, property assessments, and so on. And from BlueMetric, very pleased to have with us today Tim Beckenham, who is the Senior Director, Consulting Services and Senior Environmental Scientist. He has over 15 years of experience working in the areas of environmental site assessment, site remediation, and site management and impact assessments. And Mr. Beckenham also has extensive experience with site assessments and remediation, source water protection, environmental land use planning and regulatory compliance, and dealing with regulatory non-compliance. So Tim today will be speaking with respect to first providing an overview of environmental disasters, what kind of environmental disasters private companies in particular can expect, what risks do they involve, and what can be done to mitigate those risks. Following Tim Beckenham's presentation, we're going to hear from one of my colleagues, Meredith James, from our Toronto office. Meredith is an associate practicing environmental law, and she regularly provides advice regarding regulatory compliance and dealing with contamination sites and spills, environmental permits. Also deals with the defense of environmental prosecutions. I can speak to that point personally because I've had the pleasure of working with Meredith very recently on the defense of a Ministry of Environment, environmental prosecution. So I can certainly tell you that Meredith knows her stuff, and she will be talking today on aspects of environmental liability, and a discussion of the legal exposure using a real-life case study. Last, but certainly not least, my fellow partner from Calgary, Alex McWilliam. Alex is going to finish up the presentation portion of this session with a discussion regarding crisis management and how to manage a crisis. Alex is well positioned to speak to that issue. He is one of the leading environmental law practitioners in Alberta, and he's the Dentons firm lead for the Global Environment and Natural Resources Group and the Global Climate Change Strategies Practice Groups. He has experience also with regulatory approvals and compliance issues, contaminated land, transportation of dangerous goods, and on and on. He also, by the way, was appointed to the Environmental Appeals Board, so he sees both sides of the equation, both in terms of providing counsel to our clients and also being a decision maker with respect to environmental issues in the province of Alberta. So without further ado, I would like to turn it over to Tim Beckenham, who is going to present on environmental disasters and provide us with an overview of that.
Thank you, David. Good morning, everyone. I think we have about 15 minutes to deliver this portion of the presentation, so I'll skip through some parts fairly quickly so that we can have a fair bit of question and answer at the end of the three presentations. So an overview that's essentially, we'll work through the types of natural disasters that we're seeing and some statistics on the occurrence and the frequency and how that has increased over time, and also industrial disasters. We're seeing a fairly similar trend. We'll talk a little bit about the business risks and the adverse impacts, both economic and other, of some of these disasters. And then really more importantly is the mitigation options. What can we do to try and reduce the risk? So two major sort of categories of disasters, natural disasters and industrial disasters. You may see at some point in time that these two things converge, and there's a small case study on that recently happened in Houston, where really the natural environment very much influenced the outcome of an industrial disaster. So a significant disaster event really needs to meet one of the following categories. 10 or more people are killed, over 100 people are affected, or there is a major appeal for assistance. Some of the statistics that we'll be presenting is from Public Safety Canada, and they have quite a comprehensive database sorted geographically and regionally and by type to really show what's been happening. In Ontario, 177 natural disaster events have occurred since 1900 to 2016. They're classified into a number of categories: hydrogeological, meteorological, geological, and biological. And the first two can be grouped together, but one of the interesting reasons why they are split out is you'll see that on the following slide. Flood events are by far the largest occurrence within Ontario for this data set. You can see with 62 flood events, and then it sort of trickles down across a broad range of categories. This is also a fairly interesting statistic where you can see that from the beginning of the data set, there has been a steady climb with a peak in the 90s for natural disasters within Ontario. And we'll talk a little bit why that's happened. Some of it may be the data recording, but it's also there are influences on climate change and also the intensification of urban development sees the potential for impact within developed areas and coastal areas as a major contributing factor. So just talking to this, storms that used to occur once every 40 years now are showing to be occurring once every 6 years. So the extreme events are becoming more rapid. Also socio-economic, as I mentioned, increased population in urban areas really exacerbates the impacts. We see more people impacted. We see the intensification of development with more stormwater runoff, less natural attenuation areas, and ultimately more impact. We'll run briefly through a couple of case studies, or just examples. So in Eastern Ontario, very recently, in May of this year, there was about 240 millimetre rain fell between April 1st and June 1st, coinciding with the spring freshet. So a lot of release of snow in the upper reaches. We saw the impact right here in Ottawa with over 2,000 properties affected, including a lot of businesses. The estimated cost of this was $230 million in insured damage, but there's also a major disruption to the economy. We see this a lot. Personally, at our firm, we have an office in Gatineau, and we were shut down for 2 days, so there was a big opportunity lost there, and production was obviously down for those 2 days. Fort McMurray, although not in Ontario, really drives home some of the impacts that natural disasters can have on industry. Everybody would know what happened there. It was a major... Sorry?
Just keep going, Tim.
Yes, it was a major fire event that occurred there. Impacts were large. I think there were 2,000, let's refer to my notes here. 2,400 homes and businesses were destroyed, and obviously a local state of emergency with 90,000 people from that community evacuated. That is all very, very damaging on a personal level, but from the industry level, there was also obviously a massive impact to also sands production. Things had to be scaled back and even shut down in some cases. And the costs are estimated to be somewhere in the order of around $4 billion total damages. Oh, there we go. Okay.
There we go.
So, large disruption and quite the impact. Another not quite as recent event was the ice storm of 1998. Again, this was a massive combination of factors coming together with 5 smaller ice storms with 50 to 100 millimeters of freezing rain. Major deployment of Canadian forces to deal with this, 35 fatalities, and over 4 million people without electricity for almost a month for some of them. Again, a lot of insured damage, but then the impact to the economy was massive. A lot of lost time production, shutdown, and damage to major infrastructure. So that was some of the natural disasters that we've seen occur. Industrial disasters, somewhat different, but there are some commonalities in this. In Ontario, 53 industrial disasters since the data set of 1900 to 2016, and they've been classified in the following categories: hazardous chemicals, transportation, fire, infrastructure fail, and explosions. Again, we see quite a high peak for the industrial hazardous chemicals, with 20% of the events occurring, and then it flows through to the others. This is an interesting slide in that you can see that a very, very steady state until around 1980, and there was a big peak for 2 decades, and then a decline, maybe a potential decline. And that's kind of interesting to discuss here. Is it just a fluke that there was a few less occurrences, or have environmental regulations tightened a little bit, and have the due diligence of companies really come up and we're trying to reduce the potential impact? So another example that people are very aware of is Lake Megantic, the incident that occurred there with a major freight train derailment, 47 deaths, 2,000 people evacuated from the community, 44 buildings destroyed, over 5.5 million litres of crude oil released, massive release, 100,000 litres into the river. Estimated cost for this are more than 400 million, and then there's the liability side of things, which I think Meredith will maybe not touch on this particular case study, but this is something that companies and the industry need to be very much aware of. The personal liabilities for some directors of that company, when they go back through and retrace exactly what happened and what checks and balances should have been in place, and they are responsible for the impact. Also recently, the Arkema industry plant near Crosby, Texas, which is basically near Houston, this is the example where the environmental factors and the industrial setting really combined. On that site, there were 2 tons of highly unstable chemicals, and they exploded and burned and caused a massive impact. The reason for this is that the plant lost power and the backup generators flooded, and this was all a result of Hurricane Harvey. Because there was no refrigeration system running, no backup power, there was no prevention of the chemicals from degrading and catching fire. Again, liability, and I believe it's in the court. First responders have filed a lawsuit against the firm alleging negligence by the company. So that's all the doom and gloom. Some methods to really prevent and mitigate some potential impacts from environmental disasters. Environmental management systems is a big piece of it. Environmental risk impact assessment. And then longer term land use drainage planning. You saw that flooding was one of the larger occurrences. Moving forward, government and industry need to be designing for perhaps new design storm events where the impacts are much larger or more frequent, and essentially be better prepared for the future. Infrastructure assessments, aging infrastructure, a lot of above ground utilities, perhaps we should be moving towards more below ground utilities so we're not impacted by high wind events and ice storms. And then finally, climate change studies. Government has a role to play in, I believe, in researching and developing forecasts for the future so that we can design and appropriately accommodate the impacts of global warming. So environmental management systems, EMSs, consist of a number of components. Environmental compliance audits, legal listings, which is essentially looking at your site and your operation and what regulations pertain to your operations and facilities. Some of the lower subsets of an EMS can include tank inspections and audits. Again, as we saw, chemical occurrences were one of the largest causes of an environmental disaster, so due diligence, inspections, code compliance is a big part. Ongoing environmental monitoring and inspections, and that can include, for mining companies, geotechnical stability of tailings dams. We've seen around the world there's been some major tailings dams failures, so good due diligence on that front. And then the application of best management practices, and this is going above and beyond the letter of the law and the minimum requirements. An example of that may be a robust spills management plan and having on site the appropriate equipment to deal with a spill immediately. You may not be required for that under a particular regulation, but it is a good management practice. And you can, if you're looking at the economics, opportunity cost of not getting ahead of this can be huge. And then again, feeding into that, effective emergency response plans and training. You need to know what to do if these occurrences happen. Getting into essentially risk assessment, environmental risk impact assessment, there are a number of steps that need to be made. You need to identify the risk and establish a risk register. So we go through the operation, say if it's an industrial setting, we look at what are the major processes that are happening, what chemicals are being used, what handling is happening, where are the risks, and then evaluate these risks. What is the likelihood or probable occurrence of an impact? And what is the consequence of that impact? And at that point in time, you essentially go through a matrix and identify what are your major risks and do you have controls in place. And I'll show an example, which is the Kimber plant that we talked about in Houston. The environmental aspect there was an explosion or fire from the chemical tanks. If they had have gone through this process, they probably, more than likely, would have identified that they did not have appropriate control. The impact to the environment, obviously the release of chemicals, fire, air, water. The consequence if this happened was very, very high, and it showed to be. The likelihood was low, although because the consequence was so high, the risk rating still would have been high. And the control or the prevention mitigation measures, if they had been investigated properly through an environmental management system process, would have shown that there was inadequate refrigeration backup if that area was to flood. So, preventably and avoidable situation. Some of the other mitigation prevention measures are land use planning, as we talked about, restricting development in floodplains, addressing sedimentation and major pinch points. There are some debatable things about in terms of widening channels and dredging riverbeds. There are environmental impacts to that. So there's often a balance you see between flood control and environmental impact. We can't engineer everything because there are negative environmental impacts to that. So trying to plan ahead and build outside of floodplains and allow enough attenuation zones is really the way to go. Residential settings, building in flood control structures and stormwater management ponds, and improving drainage systems. And again, we touched on building underground power lines. We see that often in large storms and ice events, the utilities are the first ones to go, and we've talked about the impact of lost time on that. So moving forward with new industrial or urban developments, underground utilities. Again, infrastructure assessments. Do we have the correct conveyance structures, the right size culverts, the right size sewers? Can we handle these increased flood events? Talked about underground utilities. And then floodplain mapping. We need to have an accurate idea of what the potential impacts are, and they're changing. I know I used to work with the Conservation Authority, a lot of that mapping was done in the 1970s. It was on a different design storm event. Things have changed. And that's where it really feeds into some of the climate change studies and the need for research to provide the information. A lot of the design storms in Ontario were based on Hurricane Hazel. Moving away from that now, I mean, that was in the 50s, I believe, there may be new design storm events that change the game for future development. So in summary, the frequency of natural disasters, industrial disasters are increasing, maybe leveling a little bit on the industrial side. Potential impacts have been shown to be huge, very, very costly, a large social disruption. And businesses, I believe, need to play their part in their own due diligence and in future development. And David already gave a good introduction of BlueMetric, so I think I'll conclude there. Thank you.
Thank you very much, Tim. I think that provides us with an excellent introduction into the kinds of situations that we can all encounter, and also an introduction into what kinds of measures that we can put into place on a proactive basis to try and manage these crises. Now we're going to move on to Meredith James, who's going to give us perspective based on one particular case study and hopefully give us some insight in terms of what to expect and measures to be taken with respect to one disaster which happened recently. Meredith.
Thanks very much, David. So as both Tim and David mentioned, my presentation is focusing on the legal liabilities and obligations that arise following an environmental crisis. The three key messages that I hope you'll take away from this are, first, the broad scope of liabilities and obligations that can be imposed under environmental laws. These can include administrative orders, fines following a successful prosecution, and the personal liability of directors and officers. Second, that in addition to actions by the regulator, the Ministry of the Environment and Climate Change, impacted neighbors can also bring substantial civil claims for compensation. And third message, environmental crises have far-reaching impacts well beyond the cleanup costs. There can be business impacts such as plant closures, reputational damage, prosecution under other legislation such as health and safety legislation where there has been a loss of life or injury as a result of the environmental crisis. I'll be using the case of Sunrise Propane to illustrate these issues. You may be familiar with the Sunrise Propane explosion in Toronto in 2008. Some of the people on the phone or maybe even in the room may have been involved in the response to that explosion. It provides a good example of a case where everything went wrong for the defendants. The Ministry of the Environment issued environmental orders against the company. The company was also prosecuted for environmental offenses. The directors were personally charged, and the neighbors launched a civil class action against numerous defendants. So Sunrise Propane. At about 3 o'clock in the morning, a driver for Sunrise Propane completed a truck-to-truck transfer of liquid propane. Shortly afterward, there was a large propane vapor cloud explosion. The heat from this explosion triggered a number of smaller explosions, and later a second large boiling liquid expanding vapor explosion, which sounds terrifying, of the tanker that had been recently filled, completely destroying it. The explosions caused significant damage to neighboring residents who suffered personal injuries, cuts, bruises, burns, damage to their homes and businesses. The windows were shattered, the doors were blown in, there was significant structural damage. Some of the homes were uninhabitable for over a year. And as a result of the explosion, 12,000 people were evacuated in the middle of the night within approximately a 1.6 kilometer radius due to the threat of further explosions. There were some warning signs of safety issues at the Sunrise Propane site, in particular with respect to the truck-to-truck transfers. The TSSA had specifically prohibited these transfers in 2006 and specifically warned Sunrise that it could not continue making truck-to-truck transfers. The TSSA also identified a number of other issues, including a lack of employee training. Immediately following the explosion, numerous agencies responded in an attempt to prevent further explosions and harm to the community, as well as to assess the scope of the damage. As you can imagine, this resulted in a chaotic and fast-moving situation. The fire marshal took over the site and restricted access. There was initially a search for a missing employee whose body was eventually recovered. Sunrise Propane was also a member of the Ontario Propane Association, which provided a number of services to its members, including an emergency response action plan. This is based on the mutual aid of the member companies. Through that plan, Hasco Environmental would either respond or coordinate the response. Hasco did respond through this plan on August 10th and soon identified asbestos contamination, which had blown throughout the surrounding area. Sunrise initially instructed Hasco to deal with the cleanup that it was responsible for, but Hasco was soon unable to get written confirmation from Sunrise that they would be paid for their work on the site. The MOECC, the Ministry of the Environment and Climate Change, became concerned that the work would not continue and issued a cleanup order against Sunrise. The Ministry has extensive order-making powers to issue these kinds of cleanup orders and other types of order. The orders can be issued to those who own, manage, or control a property or undertaking, or a pollutant that has spilled. These orders can include preventive and remedial measures, as well as spill remediation. The grounds for issuing an order are, broadly speaking, based on preventing or addressing environmental harm. An order is not necessarily fault-based. For example, innocent flow-through property owners may be issued an order, and owners who purchased the property after it was contaminated can also be issued an order. The orders can be appealed to the Environmental Review Tribunal. However, substantial costs can still accrue during that appeal process, as there is no automatic stay when an order is being appealed. And the Environmental Review Tribunal doesn't have the authority to stay an order where that stay would jeopardize human health, the environment, or property. So back to Sunrise Propane. The order was imposed a very high compliance burden. It had very, very short timelines, some of which took effect immediately. It had a very broad scope. The order required cleanup of debris in a 1 kilometer radius around the entire site of the explosion. It was potentially very costly, and Sunrise argued that it had significant financial constraints due to insurance problems. It was also difficult to comply with respect to the cleanup of the site itself because the fire marshal still had control of the site. The order required confirmation that the company was willing to comply with the requirements of the order, confirmation that a qualified person had been hired to carry out the work required by the order, cleanup of the residential area, and that Sunrise submit a residential cleanup plan to the Ministry of the Environment. Sunrise failed to comply with this order. Although its legal counsel was in communication with the Ministry of the Environment, it did not request any extension of the deadlines. It also did not appeal the order to the Environmental Review Tribunal or to the Director of the Ministry of the Environment. As a result, the City of Toronto took over the cleanup, which took approximately 10 days to complete at a cost of $1.1 million for the residential area and $765,000, I believe, for the, that's not right, like $765,000 for the Sunrise site. I think that's probably enough. As a result of this non-compliance with the order and the explosion itself, Sunrise Propane, as well as 2 of its directors, were charged with offenses under the Environmental Protection Act. Specifically, the directors were charged with failing to prevent the company from complying with the order. Fines under the Environmental Protection Act can be very high, particularly where there has been significant harm to the environment or community. Although less serious offenses do not carry minimum fines, the maximum fine is $250,000 under a first offense, which rises to $500,000 maximum fine on subsequent offenses. More serious offenses, including the discharge of a contaminant, are subject to minimum fines and significantly higher maximum fines. For example, on a first offense, the minimum fine is $25,000 and the maximum is $6 million, both of which increase with each subsequent offense. It's also worth noting that fines in Ontario are subject to a 25% victim fine surcharge at this level. At trial, the defendants attempted to raise a number of defenses, including that it was impossible to comply with the order and that they had been duly diligent. Both of these defenses failed. On the defense of impossibility, Sunrise argued that it was impossible for it to comply with the unreasonable deadlines set out in the order, especially given the vast scope of the cleanup work. They also argued that they did not have the financial ability to comply until they had received funds from their insurer. The court rejected what it considered collateral attacks on the validity of the order. If Sunrise wanted to challenge the reasonableness of the order, they should have appealed to the Ministry of the Environment Director and then to the Environmental Review Tribunal. The court also emphasized the defendants had a continuing compliance obligation. Even where a deadline has passed, there is still an obligation to comply with the order after the deadline. It found that Sunrise had failed to show that it was not physically or morally able to comply. They also raised the defense of due diligence. The court, however, found that Sunrise was operating in an inherently dangerous industry, and as such, a preventative system was particularly important. It rejected Sunrise's arguments that it had been duly diligent, finding that it had failed to stop the truck-to-truck transfers, bring the site into compliance with TSSA requirements, provide the required oversight of truck drivers, and implement an adequate preventative maintenance system. As a result, Sunrise Propane received some of the highest fines ever imposed under the Environmental Protection Act. With respect to the Section 14 charges, this is causing the discharge of a contaminant. Sunrise Propane was fined $4 million. This was divided equally between two related companies. There was a risk that the fine could have been even higher. At sentencing, the Crown argued that there was no comparable case due to the sheer magnitude of the incident and sought a fine of $6 million. This is the maximum permitted under the Environmental Protection Act to be divided between the two companies. With respect to the non-compliance with the order, the court accepted the Crown request for a fine of $820,000. In setting these fines, the court looked at a number of aggravating factors: the widespread and catastrophic adverse effect, that the offense was committed recklessly, as Sunrise was aware of the risk of truck-to-truck transfers. The company's failure to comply with the order was motivated by a desire to decrease costs. They chose to use the company's available funds to attempt to continue to operate, rather than paying for the cleanup. They also considered that the failure to comply with the order occurred despite having been warned by the Ministry of the Environment that quick action was necessary. Sunrise also failed to cooperate with the Ministry of the Environment and other authorities, and did not take prompt action to mitigate the effect of the offenses. So taken all together, the court looked at these factors in setting these very high fines. So turning to the charges against the directors personally. Directors and officers' liability can arise in a number of different ways. They may be issued an administrative order on the basis that they have management and control of the property or undertaking. They may also be prosecuted as principals to the offense or for failing to fulfill their duties as directors and officers under the Environmental Protection Act. These duties include, among other things, preventing the corporation from discharging a contaminant and preventing the corporation from contravening an environmental order, which is what the directors and officers in this case were charged with. So in the Sunrise Propane case, each director was fined $100,000 for their role in failing to prevent the corporation from contravening the order. An important note on this is that directors and officers liability insurance may or may not cover this kind of fine or the defense of this kind of prosecution because of its linked with negligence. In addition, because things just kept getting worse for Sunrise Propane, there's also the potential for civil claims that can be brought by people who are impacted by these kinds of incidents. These civil causes of action are grounded in the classic 4 toxic torts: nuisance, negligence, trespass, and strict liability under the rule in Rylance and Fletcher. There's also a statutory cause of action under the Environmental Protection Act that is increasingly, I guess, popular in these kinds of claims. In the Sunrise Propane case, a class action was commenced by against 15 different defendants, essentially everybody with any connection to this incident. This included the Sunrise Propane related companies, the trucking company, the landlords, the TSSA, the employee who completed the truck-to-truck transfer, and various equipment manufacturers. The class action was certified against all of these 15 defendants. The shared harm of the class was the personal injuries and property damage suffered by the plaintiffs. The claim against the landlord, however, the Teskies, was only certified with respect to the claim in negligence. In 2013 and 2014, the parties engaged in global settlement negotiations mediated by former Chief Justice Warren Winkler. The settlement was approved by the court in August of 2014, and the total amount of the settlement was almost $24 million. In addition to the liabilities we've already discussed, environmental crises can also result in a number of other costs and liabilities. This can include prosecution for health and safety violations. Sunrise Propane was fined $280,000 for failing in their duties as an employer to provide information, instruction, and supervision, and to take every precaution reasonable in the circumstances for the protection of a worker in the workplace. Where a municipality undertakes remedial work following a spill, as the City of Toronto did in the Sunrise Propane case, they also have the power under the EPA to recover those costs through an order. They can also undertake a civil claim to recover those costs. The City of Toronto used both of these tools to recover the $2.8 million spent to clean up the residential neighborhood and the Sunrise site. They settled for $400,000 as a result of the global settlement agreement. There are also numerous potential business impacts. The inability to operate during the cleanup and repair. Other sites may be shut down by the regulator if they have similar concerns about health and safety or environmental impacts that are similar to what occurred at the site where the incident happened. There's also a loss in property value if there's ongoing contamination at the site, and obviously significant reputational costs. As well as these administrative, legal, and expert costs in responding to such an incident, in the case of Sunrise Propane, the defense was made more difficult because all of their records were destroyed in the explosion. So generally, to wrap up here, there are signals of environmental or health and safety issues before an environmental crisis. These can be non-compliance with regulatory standards and orders, issues identified in inspections and compliance audits, a lack of internal compliance, or just a complete lack of internal compliance audits. That's certainly a warning sign that we see sometimes after the fact. And sometimes there can be a culture of accepting non-compliance if the ministry hasn't specifically identified it as a problem. I think what takeaway from the Sunrise Propane case is that good enough is not the same as compliance, particularly in highly regulated, inherently dangerous industries. And with that, I will turn it over to Alex.
Thank you very much, Meredith. Alex is just getting ready, and we're tracking well on time. I'll just note very quickly, we do have 1 or two questions that have come in, and I think what we'll do in the interest of time is that we'll address those questions right after Alex has finished. Meredith has just finished giving us a wonderful overview of all the bad things that can happen in the context of legal liability associated with environmental issues. Alex is now going to focus on the crisis itself and how to manage and respond to that crisis. Alex.
Thanks very much, David. I think it's important at the outset to realize that what we're talking about when we talk about crisis management is making sure that a bad situation doesn't get worse. I had a former partner who's now a Queen's Bench judge in Edmonton who used to refer to these incidents as the great unpleasantness. And so we're dealing with a situation where the great unpleasantness has occurred, and we're trying to make sure that it doesn't get worse. And Meredith's discussion on the Sunrise propane case is a good example of how both pre-incident conduct and post-incident conduct can come back to haunt an organization. And it's also an example of an adage that was given to me years ago by a client that I was doing environmental risk management training for. And the in-house counsel's favorite phrase was compliance costs, but non-compliance costs much more. We're focusing on environmental incidents today, but you can see, and you're all well aware of the fact that a crisis can have many causes, and I've tried to list a bunch of general topics or general headings there that I think if you spend any time looking at them, you can probably think of one or more that have occurred under each of these. Most often a crisis comes without warning. It's not something that is a planned event, at least it shouldn't be. The other thing to appreciate by way of introduction is that a crisis of some sort is inevitable. And you can see the statistics that have been kept by the Association of Corporate Counsel, which is the largest body of in-house lawyers in the world. Their statistics show that on average a large company is hit by a crisis every 7 years. And you can see the broad categories in which they fall, including a significant number of which fall into the environmental areas. Here's the logos of a bunch of companies that have all experienced a crisis of some sort. Many of them environmental when you look at Union Carbide, BP, Sunrise Propane. So whether it's an environmental crisis or a crisis that arises due to some other source, these are the common elements. The ones I would focus on most on this list is the third bullet, the lack of reliable information. That is a hallmark of what can turn a bad situation into a crisis. Reputation, immediately at risk, and I'm going to highlight that a little bit more as I get further on. And as Meredith pointed out quite graphically in her presentation, the costs can rapidly escalate and can become a major event from a financial perspective. As I indicated, it's not something that's predictable. A crisis never seems to occur during regular business hours or at times when you're not busy with other matters. I've had calls on weekends and in the middle of the night from clients. Things just don't fit into your normal sort of work schedule. So what is it that turns a situation into a crisis? I've listed some factors that writers on the subject of crisis management have indicated can turn something from an incident, a bad incident, into a crisis. Particularly, point number 4, could it make you look bad or cause people, the public at large, social media, or investors to lose confidence? That, I think, is more and more becoming a very, very critical factor, and it's something that can quite instantly turn an incident into a crisis for an organization. Could it interfere with your normal business operations? Well, certainly if it causes a shutdown or could cause a shutdown of your operations, and also an inability to meet your contractual obligations, that can turn something into a crisis quite quickly. Churchill said a lie gets halfway around the world before the truth has a chance to get its pants on. This goes back to the point I made earlier about the lack of reliable information, or put another way, misinformation circulating. Once that happens, it's very hard to get on top of the situation. And the world that we live in now creates a whole bunch of additional pressures. We've got a 24-hour news cycle. The instant something occurs that's newsworthy, it usually gets a title of some sort, crisis in fill in the blank, and it becomes the dominant story in all sorts of news media and social media as well. And you can find very quickly that social media can actually prove to be very anti-social. The other thing is that organizations, particularly those that are engaged in activities that carry with it environmental risks, are under a great deal of scrutiny, not just by the regulators at various levels of government, but also by NGOs that are in opposition to the activities that they are carrying on. They are being watched very closely, and any incident instantly becomes newsworthy. So crisis management has a number of definitions. This is just one that I've picked out of many. The management and coordination of your institution's responses to an incident that threatens to harm or has harmed your institution's people, structures, ability to operate, your valuables, and or your reputation. It's important to realize that crisis management has two components. One is pre-incident, well, I guess you could say three. Pre-incident, during the incident, and following the incident. And I'll get into that a little bit further as we go along. These are some of the key elements of a crisis management plan. Identification of a crisis management team. Obviously, this will be impacted by the nature of your operations. It's not uncommon if you're with an organization that has operations across the country that members of your crisis management team may be drawn from across the country, and depending on the various levels of expertise that are needed. It's very critical to determine who's going to be in charge. There's the whole incident command system, of which much has been written. So it almost takes the form of a military type of operation. The other important thing to remember is that your crisis management plan should be resilient. It's got to provide clearly defined procedures, but you need also to allow for flexibility. So when the crisis occurs, obviously, first thing is follow your crisis management plan, but as I indicated a moment ago, you've got to be able to adapt to changing circumstances, so that plan should not be slavishly followed. Get the facts. The subtitle to my presentation is Be Quick with the Facts and Slow with the Blame. So obviously the most important thing early on from an information perspective is to make sure you can get accurate facts as soon as possible, and that you can communicate early, often, and obviously honestly. I've got at the bottom, apologize if appropriate. Some provinces, including my home province, Alberta, have apology legislation. In Alberta, Section 26.1 of the Alberta Evidence Act says that an apology does not constitute express or implied admission of fault or liability, and it shall not be taken into account in any determination of fault or liability. I can't remember whether Ontario has similar legislation. David's nodding at me. And some other provinces do as well, but that's important it's important to realize, and we've all seen situations in recent years where I think I used McCain as an example of that, where a heartfelt, prompt apology by the head of an organization goes a great way in terms of both taking the heat off from a media perspective, but also as things go further down the road. This isn't a new area, as has been pointed out in the earlier presentations. We've been having these sorts of situations occur for decades, so it's a little shocking to when you see FEMA's statistic that says it's estimated that less than 30% of all organizations in North America possess a crisis management plan that would actually work in the event of an incident. So when you're implementing your crisis management plan, this is a hierarchy of response objectives. You can see obviously the first one being to preserve safety and health of responders, save lives, and then as you move down the hierarchy, protection of the environment is lower down the hierarchy, but it is still there. And then last, reducing or mitigating economic and social losses. These are some of the key steps to follow in terms of dealing effectively with a crisis. I'm not going to go through them in any detail. I apologize for the size of the print. One of the key ones is sort of just about halfway down. The truth is easier to remember. Do not speculate or prevaricate. No comment is no answer. And anybody who's taken any training in communications or in crisis management will have seen some of the examples where senior executives, or in one case I think it was a senior military person, responded no comment in a situation that clearly called for a response, and how bad that can look going forward. Planning is key to effective crisis management. You want to make sure that once you've appointed your champions that they are properly trained, that they've got media training, that if necessary you've got media consultants, public relations consultant. Developing fact sheets is a good idea. Key messages, those sorts of things, so that anybody that's going to be communicating either with the media, with neighboring property owners or residents, or with regulatory authorities, has the key facts at hand and the key messages. Maintaining control over documents is also a very critical aspect, particularly as things play out down the road. Using Meredith's example, she talked about how Sunrise Propane was unable to produce records because of the incident. Whether that would have acted as a mitigating factor in any of the consequences that were visited on the company and its directors, we don't know, but obviously not having proper documentation can make defense of a prosecution or a civil action much more difficult. So a lot of this can be dealt with by way of preparing and making sure that key documents are identified and properly protected. I want to talk a little bit, just in closing, about the role of legal counsel. My view, legal counsel has a role to play both before, during, and after a crisis. And I'm not by any sense saying that the legal counsel should be controlling the process at any of those points. Lawyers are trained in identifying risk and planning to deal with risk. So I think it's very important to have your legal counsel, whether it's inside an organization or outside counsel, involved in the planning of your crisis management plan, just as it's important to have your environmental consultants involved in the preparation of your environmental management systems. Just giving some examples. They're a little bit Alberta-centric, although the dangerous goods legislation and the SEPA environmental emergency regulation requirements obviously apply regardless of where you are, but your legal counsel can identify the various legislative requirements that could require specific environmental response or emergency response plans in addition to your corporate crisis management plan. I strongly recommend that if you can do it, that you go through mock exercises, mock disaster exercises. I've participated in a number of those on behalf of various clients. They are valuable learning experiences. Even if things don't go the way you had hoped they would, you learn by your mistakes. The ones I've been involved in, we've actually had the regulators there, which sounds a little bit risky in terms of the fact that if you happen to fall down or stumble, the regulator is there to see it. But the regulators that I've talked to have all appreciated the ability to be part of these exercises and to weigh in and provide their comments and recommendations in the post exercise briefing. During a crisis, I think it's important to realize that the lawyers should not be leading the response. They have a valuable role to play, but they should not be directing this. You've got your technical people, you've got your plant managers, you've got first responders, various other people who should be the ones that are leading the response. However, having access to legal advice, whether it's on the spot or by telephone, can give you a good indication as to what your regulatory obligations are, in particular whether there's various reporting requirements under legislation. You can start to talk about whether there's contractual obligations that have to be met, force majeure, various other things, and they can be instrumental in helping you with your communication plans. Once the crisis has subsided a little bit, lawyers obviously are trained at finding facts, and again, that's one of the most important issues when it comes to dealing with a crisis, leading or being involved in your internal investigations, assisting and having input into how root cause reports are going to be prepared, handled, who they're going to go to, and obviously talking about what the potential risks are post-crisis from a liability perspective. This, I'm not going to go through in any detail. This is just an example of what is a good thing to have at your fingertips if you are advising a company or if you're in-house counsel. And I think I'll conclude with that, and we've got some questions.
I think we do. Thank you very much, Alex. I was thinking when you were going through your presentation about the points you're making, particularly in terms of communication and reaction to crises, and how important that is, especially in this day and age when we live in a world of social media, and how quickly messages can spread throughout communities and then even worldwide. And I think that point is connected to one of our questions that we've received, and this came up in a point that Meredith, you had in your slide, dealing with the Sunrise propane example. The question is, what were the associated reputational losses? And certainly you can comment if you know in terms of that particular case, but also more generally, what is the issue in terms of reputational losses, and how would we deal with that or quantify it even?
I don't have access to any numbers on reputational impacts to Sunrise, but after seeing this question, I did a quick Google search, and the entire first page of Google search results is about if you search for Sunrise propane, is the explosion. The first entry is actually the Wikipedia entry on the explosion. So that's obviously a huge impact if you're trying to continue operating, that your ability to even market your services is impacted by the media coverage on these kinds of incidents. Two other aspects in terms of reputational impacts I think that are worth keeping in mind are also your relationship with the regulator can change after a significant incident like this. You may be subject to increased scrutiny going forward, both at the site where the incident occurred and your other facilities. And the other impact is your relationship with other businesses. Sometimes when you're bidding on contracts, you're required to disclose your enforcement history, and you may lose out on bids to provide your services going forward. or if you're trying to sell your business, again, the due diligence process of the buyer will discover that you have had these incidents in your past, and that may reduce the value of your business and its marketability.
Great. So we do have time for a couple of more questions, and we've got one here. But if there's anybody else who's listening that has any questions, now is the time to just use the chat feature on the webinar. Send in your questions, and time permitting, we'll deal with them. The other question that we've got on the board at the moment is also, I think, very much related to communications, particularly in the context of crises. Alex, you mentioned in your presentation the apology legislation that's in Alberta. There's also similar legislation here in Ontario. Can you expand a little bit on what that legislation is intended to do, particularly in the context of making communications in response to a crisis?
The legislation is intended to allow persons, and persons being individuals or corporations, to step forward and express regret and apologize for incidents that occur without fear that that expression of regret or apology, or saying we're sorry for the loss of life, or we're sorry for the damage to the environment, will be used against the individual or the corporation in a subsequent proceeding, whether it's an environmental prosecution or a lawsuit. So it's intended to allow organizations to take those steps, which you've all seen in response to various incidents. Lac-Mégantic's a good example, the BP Deepwater Horizon blowout, where the initial responses and the public statements made by the leaders of those organizations have not met with any favor, both from the impacted people and the media. And they've taken, to go back to my original slide, they've taken a bad situation and made it even worse because of the fact that they didn't come forward initially and say, we're sorry about this. Now, whether those initial statements were made in the way they were because of concerns about potential liability or not, I don't know whether that's the case or whether that's just the individuals involved deciding to take that route. But the idea of the legislation is to allow and encourage those sorts of things to happen without the fear that they can be used against people going down or further on.
Right. Does anybody have any questions here? We have a few folks in the room who are with us who have listened in on the presentation, and if there are any questions, now is the time to speak. One thing that I noted, Alex, when you were talking about the role of legal counsel during the crisis, you had a point about protecting privilege, and that's certainly something that I've been asked about many times in respect of either crises or sometimes clients being proactive in terms of setting up systems to protect privilege, which obviously relates to how they manage documents. And one of the things that I always say to clients is not to assume that they have privilege. Just because you put on a document privileged and confidential does not mean it is going to be seen as privileged. It very much has to do with context and with what the purpose is for the document, the context in which it was created. The other thing to point out about privilege is that it's not a mechanism whereby you're meant to be hiding something. The purpose of privilege, or really any type of privilege, is to have a zone of protection with respect to communications, usually for the purpose of seeking legal advice. And the reason, of course, why that is so important is because the sooner you get the best legal advice possible, particularly in a crisis situation, the better able you will be able to manage that crisis and mitigate the harm that's associated with that crisis. And so that's why we have these kinds of protections, and that's why it's important to preserve them. And certainly that's a significant role of legal counsel in terms of creating and maintaining that privilege.
Yeah, that's an important point, and I'd be interested in Tim's view on this when it comes to environmental audits. Now we're talking about preventative steps that are being taken by an organization. So this is pre-crisis, but the use of environmental audits has been recognized by the courts as evidence of due diligence. Different regulators have different views about whether they would respect the privilege that might be associated with an environmental audit. Sometimes the environmental audit is just done by the environmental consulting firm for its client. Other times it's routed through legal counsel, whether it's in-house counsel or outside counsel. So Tim, I'm just curious about your experience with respect to audits. I don't know what the view is of the regulator here in Ontario, whether they will want to seize an audit, for example, if there's an investigation, and in which case you might want to be more proactive in terms of trying to prevent it or cloak it with privilege, or whether they try to encourage audits to be done and say we're not going to hold these against you, because typically an audit will usually find some examples of non-compliance. That's why you do it.
Yeah, my personal opinion would be that it is a good step towards due diligence, and if you uncover some corrective actions that require to be filled, then that maybe is where the risk is, that you document that we know we are not meeting these regulations, and there's a recommended corrective action from, say, the consultant, and the firm does not undertake that corrective action. To be honest with you, I don't know what the legal position would be there, but I think it would be something that would be needs to be taken under due consideration, for sure. Although, having said that, I believe the potential for positive, I think that's a fairly reactive approach to things. I think the positive outcomes that can come from such an audit are huge if the company undertakes the corrective actions in a responsible manner.
Yeah, that's certainly been my experience, which is that a regulator will not take issue or will not use the fact that an audit uncovered examples of non-compliance. Where they do get very concerned, obviously, is if there's an audit. I'm creating a technical term now, but if you've identified a number of areas that don't get addressed going forward, that's pretty damning evidence of a lack of due diligence on the part of the company.
I have a question for Meredith. I was going to tell you I work in mining, and right now we're trying to revive a local mine on Manitoba, and we've had to postpone. In your presentation, you said that the environmental regulators actually denoted the propane company as being high risk. And so I know in my legislation where posting a bond is necessary, but I haven't worked in environmental. And so why would there not be a section in the Act, or is there, and I'm not saying mining, but propane, gas, whatever, anything that would be deemed high risk that they pose upon. Because we had to post fairly significant bonds 25 years ago.
There are financial assurance sections in the Environmental Protection Act, but they're generally used where there's a known environmental risk. So the classic example is a landfill. So you'll have to provide financial assurance to the Ministry of the Environment that if you walk away from your requirement to close the landfill in a responsible manner, that they can access that financial assurance to close the site appropriately. So in my experience, these financial assurance requirements are used for known environmental costs that are coming in the future where there's been a problem with getting the company to actually comply. I've also seen it in sometimes in certificates of property use where there are ongoing monitoring or mitigation requirements that are known. So
I just find audit is not a catch-all, because you specifically used the phrase in your presentation, deemed to be high risk.
No, and that's part of why I flag this case, is because it's new interpretation by the courts that there are some industries that are more dangerous than others where there's a higher standard of care perhaps required.
Yeah, I think the other way to distinguish it is along the lines of danger. In the Sunrise propane case, we're talking about an accident. So if things had been done according to standards and those sorts of things, there never would have been this incident with a landfill, with oil and gas operations, with the mining operations. These security requirements are really intended to cover post-closing decommissioning costs, which you know for sure will be there. And typically, in a lot of cases, are even identified as part of the approval process. Whereas, I know it does seem a little strange because you've got other activities that are deemed to be potentially dangerous, but that's only if the circumstances come together to create sort of this accident. So really, I think what you're talking about is maybe even more like an insurance fund or something, maybe on an industry basis that would respond to these sorts of things. And I think we're starting to see a movement towards that in the rail side as a result of Lac-Mégantic and when it comes to transportation of dangerous goods.
Okay, well, we just have another question here. What was the legislation that identifies some industries as more dangerous than others? I don't know if that was legislation, Meredith. I think you might have been referring to the case law.
That's correct.
Yeah. And it was the Sunrise propane case in particular that had that content in it. Is that correct?
That's right. And there's a citation to the case if the person with the question wants to look it up, or I'm happy to send it to them if they'd like to take a look.
Okay, that's great.
Sorry, I have one last question, and I didn't even do contact registers, but I do also a lot of board working for training, and what the question I get very often, I'm happy to go back and read that case, is that often not all directors are equally liable, which I find shocking. If you're on the board, you're on the board. But in your case, so everybody was fined $100,000, then two actually had the extra charges against them. And so I would like to go back and read the case to find out why two of the board members had a higher degree of liability than the other. Now, I think I know the answer. Because again, if you're a GO or a lawyer sitting on the board, your liability may be a little bit different depending on what. But do you know the answer? Because I'm going to be happy to go back and read that.
I would have to go back and double check the case for why these two were named.
Mm-hmm.
They may have been the ones who, I suspect they were the ones who were actually dealing with the Ministry of the Environment on that matter. But I have been involved in other cases. This is related to the North Star insolvency, where the Ministry of the Environment named all of the corporate directors and for both the Canadian company that owns the lands here and the U.S. parent. And they made no distinction between which directors had been on the board when the contamination allegedly occurred and those that were in the U.S. or in Canada. They just named them all. And that, whether that was appropriate or not, has not been decided by the Environmental Review Tribunal or a court because the matter's settled.
And it said it's determined what the subsidiary and liability on the subco is equal to parent code from under
Well, I'm happy to send it to you, but the thing is there's no case law on whether or not the ministry actually has this power to name the people so broadly. And as I spoke to this a little bit, how expensive it is to appeal an order to the Environmental Review Tribunal because you have your ongoing compliance costs during the appeal period. So it makes it very hard to hang on during that appeal. So they settled. So the ministry is using this power, waiting for the case that refutes it.
Typically, when a director is being charged under the legislation, that will have a specific section that says directors and officers who consent, acquiesce. There's sort of about 6 words that if you fall within one of those, you can be guilty of an offense, even if the corporation itself is not charged or convicted. They don't normally distinguish among directors, where you might see consequences different would be perhaps where a CEO or somebody who's also an officer of the
Right.
company, more of a directing mind, also happens to be on the board. So the additional liability that they face may be a result of the fact that they're both a director and an officer of the company. But normally, it would go to everybody on the board in the same fashion.
Yeah, I should have distinguished between the two in my answer. One is the administrative orders that can be issued to anyone who is management or control.
Right.
And the case law says that directors and officers are deemed to have management and control. And then the other is the prosecution side, which where a director fails in their duty to prevent the company from discharging a contaminant or complying with an order, then they can be prosecuted for that offense. There's two streams of potential liability.
I have a question, perhaps a naive question, but if someone was a former director that moved on, are they still liable for past?
Yes, if it occurred, if the act of consenting to or directing or acquiescing in the conduct of the company occurred while they were on the board, yes, they can be liable.
So to sum up, plenty of exposure. The regulators have a great deal of power in this area, and there's also a significant amount, as we see, especially in the Sunrise propane case, a significant amount of risk and exposure on the civil side. And so lots to think about, but also lots to do proactively in terms of putting together, for example, with Alex's presentation, a crisis management plan and thinking about steps that you can take proactively to put that sort of thing in place. And also, even on a day-to-day basis, particularly if you're involved in an industry that is associated with environmental issues or some environmental risk, the Ministry of the Environment can come knocking at your door at any time with respect to, for example, a contaminant that has been discharged into the environment causing an adverse effect. And you may not know about it until weeks or months later. So it's not just a obvious case of an explosion in the Sunrise propane example. It's also certainly relevant to day-to-day business and how you conduct that business. And for me anyways, a strong underlying point to all of the presentations today has to do with emphasizing the importance of being diligent, which is of course directly related to the due diligence defense that's available in these kinds of situations. So thank you very much. First of all, thank you to BlueMetric and to Tim for coming in and giving us a great overview in terms of the kinds of issues that BlueMetric faces and deals with on a regular basis. And to my colleagues, Meredith and Alex, for their expertise in this area and their presentation. And to our guests this morning, thank you for coming in and joining us. And to everybody out in webinar land, thank you very much for your questions. Thank you for participating. I indicated earlier to somebody online that we would be making sure that this webinar is available for future listening and also the slides as well. So if anybody has any questions about that and needs the material sooner rather than later, they can by all means contact any one of us at Denton's. We'll provide that information, but I'm sure it will be available on our website in due course. So thank you very much, everybody, and have a great morning.